So are we up?
Yeah.
We'll get started. Call the meeting to order. Roll call. District one, Mr. Jeffrey Lee, Vice Chair.
Present.
District two, Dr. Samuel Bame. District three, Ms. Diane Easter. Present. District four, myself, Felicia Harrell, Chair, present. District five, Ms. Jasmine Willingham. Present. Tax Commissioners appointees, Mr. Nicholas Craig,
Present.
Mr. Lee Kelly.
Present.
Clerk of Superior Court selected alternate members, Dr. Erica Pike. Present. We still have a vacancy. All right, we done, can I get a motion on the floor for the approval of minutes from two previous meetings?
I'll make a motion to approve the meeting minutes for 2/5/26 special call meeting and the meeting on 2/10/26.
Second.
All in favor? Vice Chair made a motion, second by Ms. Willingham, all unanimous. We'll move on to item C, general updates by the ethics officer. Where do we want?
The ethics, I'm sorry, I'm used to you saying ethics administrator. As it relates to updates, good evening, Chair. We are in our way of training. We have trained 39 people in person. We are currently working on a virtual year. I have a meeting that is being scheduled with Mavix on Thursday. I have kind of hit a slight technical roadblock with this being our first in-person year of creating what they call pretty much the groups that go out per department. So that's still in the works to start virtual training with all of the departments, but I am scheduled to meet with Navit on Thursday. Other than that, we continue to train the new employees as they are rolling in.
Quick question for clarity. Did the online training the previous year, this year we're rolling out in person and you're looking to, submit the modules for in person?
Flip it.
Flip it.
We did. In person last
Now we're
year.
going to, and you need to update the modules.
Correct.
Okay,
Exactly.
thank you.
No problem. The board may recall that I discussed wanting to do lunch and learns with department heads and cluster leads. I am waiting to see what the budget looks like. We should know in June whether or not we are able to have those lunch and learns. So hopefully that was budgeted in. We'll have some funds. That'll be a great opportunity for department heads to come and get a more in-depth understanding of not only the code itself, but how it's applied, more importantly, how it's applied, because that's where the confusion arises. So we'll be on hold until we can get more information about that budget in June. Any other questions?
Just one clarification. Is the budget for the additional training or is it for the lunch and learn?
So there's a category for us being able to do the training, which would include the lunch and learn.
Okay, is it bring your own lunch or we're providing lunch?
It depends on what the budgets will allow for. Idealistically, I would want to provide the lunch that incentivize people to actually come. If they have to bring their own lunch, I dare to say we won't have a good turnout.
No, thank you.
Any other questions? We'll move along to the case status. As it relates to the case statuses, we currently have no probable cause cases that are pending right now. We do have one case that has been stayed. That will be stayed until further decision. We have one case that is ready for a hearing. That is Tripp versus Morris and Human Resource Employee. So we'll be looking into getting that scheduled whenever we can get that scheduled. Are there any questions about the cases? Any questions in general before I conclude my presentation?
So just an FYI, we're not moving forward with any hearings until we get more money to move forward with hearing. We're out.
That concludes my presentation, Chair.
Thank you. We're gonna move over to item D, review of policies and procedures. And I did not ask you to print a copy of policies. Does anyone have,
I printed it, Chair.
okay, you did, you have it?
Everybody.
Thank God. So we'll get started on the policies and procedures. I have my list of items. We, of course, we trained on the 28th of February, which was fun. And, but in the midst of training, we noticed some things that may need some discussion and updating. And so I took notes of the items that perhaps need updating and discussed. If there are additional items, please, bring it to our attention as well. But would anyone like to start before I get started in my list? Anybody have any questions, concerns, thoughts? Okay. So I'll start. One in particular item for discussion is the 5 days for witness and evidence submittal. I'm not sure what page, the item number it is. I think right now, I'm not sure if it gives 7 days or 10 days. Thank you.
Seven is what.
What page are you on?
They talked about the witnesses on page 13, page 1012. And there's claims of the witness in 7 days. On page 12, 8.105 is the exhibit.
So exhibits, documents, photographs, recordings, or other exhibits that you would like the board to consider during the hearing must be emailed to the ethics administrator 7 days or before hearing begins. Exhibits will need to be numerically marked for the board. What was the other point? The witness, both parties have the right to present and cross-examine. The ethics officer may call the respondent as the witness, name and address of all witnesses. The parties will call or may at the hearing must be exchanged within 7 days of any hearing. And the questions that I had for those particular items really is that, do we need to shorten that period given the flood of witness information that typically comes forward right before hearing? Or is it more responsible for us to keep it at these 7 days? Any discussion on that? Ethics officer, what are your opinions, thoughts, needs?
I think typically 5 days is a good amount, 5 business days would be good to have. I will tell you in practice, I have gotten things the night before. And I think it's because a lot of times people are thinking about things as they get closer, and if last minute things come up, they just email it so that the board will have it for consideration. 7 days may be too long. 5 business days, dare I say even 3, would probably be sufficient. The whole purpose of the exchange prior to is so that we have time to prep it for the board, so that the board have the proper copies and things of that nature, but also so both parties are fully aware of the witnesses that will be called, so they can anticipate any cross-examination or things of this nature.
So my question for that would then be, if you change the date or the number of days for them to turn over stuff, what do you do about the number of days for the witness list? Because if you get something that now includes a different name and you're also at that deadline for witnesses, you don't get to add them.
I think the witness day should be first, and then the evidence day a different day. Because to that point, if I get notice of a witness, I can anticipate things that may be needed for rebuttal of that witness that I didn't give them on that same day. But if I have 2 extra days, I can prepare that, because now I know who the witnesses will be.
And I get that. I think what I'm saying is, if you get evidence that lists someone's name in it that you did not know prior to getting that evidence, your deadline for your witnesses has passed. You can't call that person as a witness.
I think if at that point, it will probably have to be a case by case, and I will be asking the board or for continuance and explaining the reasoning behind it, indicating it was pretty much an unfair surprise. Now I have new information and I need time Yeah, because it's not to do.
Is it all business days or is it calendar days on the other 8.102 and 103?
It is what it is right now. How you read it, this is our current rules and procedures. I think that
Can we clarify to business days if we want to use
whatever
it?
you want to clarify to them.
So, or is the board in consensus on wanting to maintain the 7 days and change just the second 8.1012 to business days? Or are we gonna change 1 to 7, 1 to 5, keep 1 7, change 1 5? But also, when speaking of a continuance, we're talking about money. And this board has $0 to waste. And so if in a continuance, how does that work when rebooking or having to rebook or change the schedule for our hearing officer and our court reporter? How many days prior to a hearing can we cancel or reschedule?
But not yet, but I would imagine they're still gonna charge us for their time. For that, whatever time they were there that day. And,
No. So if we cancel 5 days prior, what are your contracts?
well, there is no contract. It's,
Case by case.
yeah,
Typically with court orders, you have about 24 hours to cancel, without a penalty or anything of that nature. And I don't think, the hearing officer has never,
he's never.
charged us even for last minute cancellation. I will point out to the board that business days is defined within the policies. So it may approve the board to use the word business days because it's actually defined in the definition.
On page 12, 8.105, it specifies business days, but on 8.1012, page 13, it doesn't, so we just need to update one
Oh,
on page 13.
12 and 13.
I'd say 13 to 2, because then you could have a clear understanding of business, 7 business days.
That makes sense.
But we, 8/13, got virtual appearances, they have to give notice within 7 days, so it would just change that.
In other words, anywhere where it says days, it needs to change to business
Business
days,
days.
anywhere in this. Yeah. Okay. The number of days, are we changing the witness days to 5, or are we looking for her to update and keep it 7 and 7 and just update the language of business?
And if I understand, right, I think to clarify, and so everyone would know, there will be no exceptions to this. Right, that's how the board uses rule, it's not, it's changed, it's not coming in.
I think that depends on a case by case, because in this last hearing, the evidence necessary for the respondent was presented the day of hearing. Which was something that could have been asked for prior to, but it wasn't. And so we would have not given her opportunity for that.
In 13, it says, and will only be granted for good cause. So I guess I didn't read the start of it, but I would imagine that we have the leeway to
Appear shall be submitted within 7 days of the hearing. That's pertaining to virtual. We can get that language added to both,
well, that's
granted for the cause. I think
I mean,
it
should.
that should be. Is that for witness as well as exhibits? Yeah, I think it makes sense. Next item, we're gonna come back to, I have the next item as being the subpoena quashing, but we'll come back to the end. So I have in here conflict of witness sworn test statements made a part of the record compared to the rule of evidence of sworn statements being used.
That was something the board, wanted to discuss. According to the code, everything has to be done in accordance with the rules of evidence. However, the code also states that a witness may give a sworn statement. Which if a sworn statement is presented, it cannot be used or it technically is in violation of the rules of evidence. So there's a direct conflict in the code itself. I believe the board wanted to kind of walk through that conflict of if that arise, what
Okay, so let's take a look at the code.
look at, you want to look at the code or the rule, because it is verbatim from the code. The rule is verbatim from the code, which is rule 8.108. Page 13.
What was the question on this? Like, what was the concern? Remind me.
So the rules of evidence does not allow hearsay, which is out of court statement to be taken into consideration. But so the code says hearsay is not allowed, because we have to abide by the rules of evidence, but it also allows for written statements to be included in the record.
So written statements can be not, is it not considered a sworn statement?
It is, well, under the code, they file a written sworn statement for incorporation into the record. May be part of all the proceedings, which
But-
will include the final hearing.
But under the rules of evidence, that would still be hearsay.
Why?
Because it's an out of court statement used for the truth of the matter asserted. So it is not a statement that's being given at that time in court, but you're using it for its truth. You're using it to say that what that person is saying is actually true. So that would be considered hearsay unless it falls within one of the exceptions of hearsay. And without seeing an actual statement or knowing why it was provided, I couldn't say that it would fall within one of the exceptions, but
What are the exceptions?
Utterance, it's not
Entire
utterance. Mental impressions, thinking about it.
yeah, presence is.
Mental impressions,
Presence
present sense impressions. They're used so far in between that the attorneys here can't remember.
Okay,
We gotta
excited
get general counsel there.
present sense impressions, business records, state of mind, statements for medical diagnosis, dying declarations, prior inconsistent statements, and
consistent statement.
statements against interest.
What was the business portion?
Business record would mean that it has to be a certified business record. So like, for example, when we get the HR record, like when we get that, and it's a certified copy, so that is then that falls within the business record exception. But that's why I said I can't think of any instance where a person's sworn testimony would end up being, unless it was their dying declaration. But outside of that, I can't see any reason why that would be considered a hearsay exception.
No, you go ahead.
But also, we can also consider maybe the person is cognitively impaired at the moment. Right? So if they had a statement prior to, that could be used, right?
I would object to it.
Why would you?
Okay.
I would say hearsay because it doesn't fall within one of the exceptions. So I would object as an attorney, I would. I think the question becomes, if that's something we want to use, I don't think it's as much us trying to parse out how it's not hearsay as much as us trying to determine whether or not that is going to be an exception, and it would have to be defined, because right now, if you're saying the rules of evidence apply, if you don't follow that one and it's not written anywhere, then realistically, all the other rules of evidence are thrown out too.
So, question. So what consideration are we giving the sworn statement?
Shoot. Yeah. I mean, because the code allows for it. But technically, the complaint itself is a sworn statement, is it not?
Go a little further.
Verified, yeah, so it is.
It is.
signed by the individual, but it is considered more of a plea. A part of it's a pleading within the record itself. The way that this will play out is, let's say we have a hearing tomorrow. And I go to someone in senior services and I say, hey, I want you to write a sworn statement, here's the notary, because I want to present it to the board. Now, tomorrow I come and I present that to the board. It's really unfair to the other side. Because now you are considering a statement from somebody who is not there. And you can consider that in your deliberations and ultimately your decision making.
And the prime reason hearsay isn't allowed is because of the lack of ability to cross-examine the person. So if I don't have an opportunity to cross-examine them, then I just have to assume that everything they wrote is true. And I have no way of being able to pick apart their story or flesh things out to make sure that what they're saying. So that's the reason hearsay isn't allowed.
So realistically, this board has the authority to allow sworn statements based on the code itself. However, based on the law, evidence, rules of evidence, we can't. And so just as a cautionary move, we shouldn't.
So it's not that this board has the authority per the statute, this board has to allow sworn statements. So it conflicts itself. But
Straight, I'm finished.
I think the suggestion that I would make is that because the code says, one, you have to follow the rules of evidence, and you have to allow sworn statements, that any sworn statements be filed with this board in an X amount of days to give the other person opportunity to either subpoena that individual, call them as a witness. So have a limitation around the filing of that statement, since you have to allow the statement to.
I would agree with that.
Are we talking about 8.108?
Yes.
Yes.
This is speaking to someone who's adversely affected. This is not.
Witness feels like they're adversely affected. Everybody in interview feel like they're adversely affected, because if their name is drawn into an ethics complaint, they feel like they're adversely affected.
It says here, any person whose name is mentioned during a proceeding. So you're saying that that individual who is actually the defendant will be covered under this, and you think that they would actually file a written sworn statement?
Not the defendant, the witness.
The witness.
Correct. So if somebody's name is mentioned in a preliminary hearing, that's a proceeding, and they now feel like they could be adversely affected by anything that goes further. So they could file a sworn statement, or I can get them to write a sworn statement because they're biased.
Can we
literally have a pending case because of that right now.
Can we define the right of person adversely affected? Clarify that, meaning that the individual who's not in the court proceeding directly.
And I think it's defined. I think it clarifies it because it says the person that's mentioned, meaning that in itself tells you it's not complainant, nor is it the respondent. It's
That's
just.
what I was thinking.
Yeah.
I said, but you said no.
I didn't say no. I shake my head all the time at things. You know.
That it might not be.
Oh, okay.
Complaining, but what he's saying is that anybody that's mentioned, if somebody is called as a witness, they're always going to feel like they're adversely affected, especially when you're talking about the type of cases we're dealing with. Because as we know, a lot of them blur the lines with HR. And with that, people are going to feel a need to defend themselves. And when they write that sworn statement, it then goes against the rules of evidence.
So the other part of that, you were saying it earlier, if that was due, any sworn statements were due 14 business days prior to a hearing, that gives them 7 business days before finalization to go fact check, do call, whatever they need to do, or.
I think that's a fair compromise.
I think so too.
Repeat that, we're changing.
So this one, we would do 14 business days. Any sworn statements are due 14 business days before a hearing, giving the other side 7 days to respond, question, call, whatever, before the 7 days of everything is due to be printed, done, whatever.
That makes sense.
That goes back to my other question, the consideration, if, are we considering the sworn statements?
The code says we have to, yeah.
It says it would be incorporated into the record to be made a part of all proceedings. So if it's incorporated into the record, I don't know how we wouldn't consider it.
They have time to check it, do it, ask questions. So
Or
they're-
subpoena the person if they want to cross-examine them.
Which is great because it makes for a more thorough investigation.
We discourage people from doing that too.
You know what?
But you have to. I mean, in all fairness, you
I
can just
understand.
throw something out there on a person's name.
I agree, but it balances out. Let me use another word. It balances it
It
out.
does. That's
Okay.
scale.
Yeah.
Say something you don't mean. All right. Moving on. Or are we ready to move on?
I have
So,
a quick question.
Yes, ma'am.
Before we move on. I know we clarified business days in all aspects. Did the board decide to keep 7 as the number?
7 business days.
Well, which one?
Or
Which one?
was it 5?
It was between 5 and 7. I think we didn't move it from 7. I mean, we kept it at 7, yeah,
So keep it at 7?
unless there's.
I think the witness list. Give me 1 second. I think one was 7, one was 5. No, we're gonna keep them both at 7?
One was business, one was non-business. day.
Yeah,
So
we need to
clarified.
clarify all the days to business days, but did we not say exhibits 7 business days and maybe keep the language? You know what, actually, no, we keep it the same because we're gonna add the language, yes, granted for good cause. Yes,
No, the board is keeping or changing everything to business days, but keeping the 7.
yes,
Okay.
on both.
And adding.
And they're adding to more like.
And adding the language for, granted for
Got
good cause. On both, on both.
Is that for 8.105? So 5 business days or 7?
They're gonna stay 7. So 8.105 will stay 7. 8.1012 will stay 7, adding language, business days to 81012. And adding the language of business days throughout the entire document, policies and procedures. And then adding granted for good cause for 8.1012 and 8.105. You're welcome. Public reprimand. We decided as a board, the public reprimands will no longer go into the newspaper. So we will maintain that reprimand on our own website. Any discussion or objections to that? Fishing board. Discussers. Responded 8.7 and 8.8. Respondent within 30 days? Answer, failure to answer, 8.7 and 8.8. The respondent shall file a written answer with the ethics board within 30 days after notification of the formal investigation unless the time is extended by the board. 8.8, failure to answer upon proof of receipt, failure to answer after notification of the formal investigation shall constitute an admission of factual allegations at the board's discretion. Can't remember, but what was the concern for that one?
One question you all had was, how was the notices delivered? How do you prove that upon the receipt? I explained the best as I could, what I understood that ethics officer should does, which send it with their receipt and hand delivered to their mailboxes. Did I miss anything?
They're still county employees, it gets, statutorily from a service to their county email address. And I also put a copy in their Dropbox or their department box at the admin building. If they're no longer a county employee, then one is sent certified mail to them. And if we don't know where they are, then we use the process server.
And then I think the board had wanted to discuss that it shall file an answer or, that it shall constitute an admission. And I think some board members, had questions about that, if I recall correctly.
Although I think there were questions brought up, I thought we acknowledged that the discretion part at the
Cleared it
end
up.
kind of clarified that.
It does,
Okay.
it does. And we use that discretionary, so. Are we ready to move on to the next item? Any questions, concerns, thoughts? Yes, ma'am.
I'm looking at this motion to quash mandates rules. Talks about they must respond within 30, you said 30 days?
Yes, upon the notification of an official investigation. So once we've gone from preliminary hearing of probable cause.
Yeah.
Once we've found probable cause, if probable cause found, then they're notified that an investigation is started.
But that's for the answer. That's not necessarily for the motion to quash.
Okay, well, the motion of quash said that once we notify them, they have 30 days to do the motion.
Yes, and we're gonna get to that whole document. That's gonna be a whole ball of wax. Why you have stuff. Okay. So y'all ate those snacks way too early. Let's move on. So what about those 30 days? We're good. Yeah, because it's at the board's discretion for 888. That's it. That's it. Now we can move on, actually, Ms. Easter, to your questions pertaining to the motion to quash. Ms. Easter. You have.
No, but which one did you just read? Did you read that one? Last one, page 12. What number was it?
The last one I read was 8.7 and 8.8. That's on page perhaps 12 of those. Yes, sir.
I'm just trying to see if they were the same. This is.
Okay, we'll move on to the motion to quash or modify witness subpoenas. 8.161 is where it will be added. Really? Let's see, where are we here? With Dr. Valme, I think your hand, see some highlights. You
Oh.
started.
No, I just have a couple questions. That's all. Section 7. Just for clarification, just add the word calendar, 7 calendar days.
Business days.
No, it's not business
No,
calendar.
I'm saying you want to change it to business day.
No, I want to keep it calendar unless there's a change. Because on section 4 is calendar.
Let's go back.
Right, all the calendar days, we change the business day.
So you're gonna change the calendar days to business days? Okay, that's fair.
Any additional questions before I go into my litany?
The other question I have is just one more. We have here 10 days,
Will you open that door, please? Oh, thank you.
10 business days, and we're doing 7 business days on this one here. I'm just wondering, is that what we really want to do as far as a 10, or is it across the board 7?
that may be something to discuss, because if you're saying the witness list, well, if you're not subpoenaing them, I think we are gonna run into an issue with that, because we have less days already in terms of that witness list. So if they decide to go and subpoena somebody, well, they already don't have time anymore for their motion to quash.
It's gonna change, yes, and perhaps I put the cart from the horse, but I knew this would be a heavier discussion. And we may have to go back and readdress the days, the policies, procedures, because to be quite honest with you, with the way this language reads, it's almost like we can't even have the hearing itself till maybe 15, 20 days after we've gotten through all of these motions. So because if they wait to that 10th day, then they have the additional 7 days or however many other days, we're extending that hearing out. So it almost seems like everything pertaining to witnesses need to be done almost 30 days prior to a hearing.
But this is a witness though.
It is, but when they have all their abilities to activate those motions, it extends it out quite a bit.
And although this is a witness, I think the question becomes, if she doesn't have to send out her witness list or doesn't get all of her evidence, and now she's decided to subpoena somebody else, you're already outside of the 10-day window. So that person is gonna get that subpoena and they're already not
Okay.
gonna have time to respond to it. Unless you add for discretion, but it sounds like that would always end up being an issue. So we can always be using discretion.
Oh, so I guess the question you're saying, what you're saying is that we have to build in the 10 or 7 days in our case, based off of the subpoenas, the motion to squash. And I'm sorry. Oh, yeah.
Or the other one that was 14 days.
Yeah, then you have to back into the 14 days as well. That's kind of ridiculous.
Do we think we really need
Yeah.
10 days for them to file a motion to quash? I mean, I get giving the time, but I do think that is an excessive amount of time for us to not be able to, like, just kind of be in limbo with the hearings just because we're waiting on that.
I don't think so. I think I would have to ask Maisha. We worked together on this and I didn't have time limitations in mind. I don't know the rationale of adding them, so she may have a different train of thought.
So I did add they're kind of arbitrary though, because I think it was just for discussion, but I wanted to add that time limitation so you all could kind of bounce back and forth between that. And then also, the fact that somebody's gonna file a written response to, or you're gonna allow somebody to have a written response to the hearing officer's determination. So if it was 3, I think it could be 3 days, just to kind of just
And I
wanted to
think
put
that
that
makes
time
sense.
limitation.
That makes
So it's not like somebody's walking in there and serving it the morning of, and now there's,
I didn't put a time limitation in it because a motion, and to me, in my opinion, a motion to quash can be filed all the way up to the moment of the hearing. Because if we include somebody on the witness list, and let's say the process server got them served the day before, because they had difficulty finding them, then to me, there doesn't need to be a time to file a motion to quash. They may file it in the morning, and at that time, the hearing officer would take it into consideration before moving on. So that's why I didn't.
that doesn't make sense. I'm thinking
That
about
makes-
service issues.
But if,
So that doesn't make sense.
so if we give them the time, we have to honor that time.
Right.
So we're not giving them,
We're not getting.
Take the time.
we'll take the time out. They just have an opportunity prior to a hearing.
So you adding that language?
Yes, we're gonna mark this and add it. So what I'm gonna do, because now I'm gonna start at item 1. We're gonna start at section 1. Let me tell you, because my whole brain is not, it's like, that's like a ping pong over here. Well,
Okay.
all right, so let's start with section 1, applicability. Are there any questions, concerns about applicability? Section 2, standing. I have a question about standing. It says a motion to quash or modify a witness subpoena may be filed by 1, the person to whom the subpoena is directed, 2, any party to the proceeding, or any person, 3, any person asserting a personal right or legally recognized privilege in the testimony sought. For purposes of this rule, party means the complainant, the respondent, and the ethics officer. Does this language, does item 3 include attorneys for the respondent?
So
Because,
it says respondent, but when a person is represented, it's insinuated that their attorney is acting through, the respondent is acting through his or her attorney.
so let's, can we add language though? Because I don't want
Attorney is not
insinuation.
Party of the case.
It isn't a party, but any representative of the party of the case?
Well, the attorneys, an attorney that reads this would recognize that.
Okay, it's
They
fine.
would recognize that as respondent means it is,
Okay.
yeah.
That the respondent acts through their attorney.
Okay, I just want clarity because we're one board, understanding clarity. If it moves to another board, these rules or procedures and policies, is there enough clarity spelled out for them? For anybody, for them to say, hey, I object because they're not 1, 2, or 3.
Okay, so I do have a question about that. Based on this rule here, how does the respondent's attorney handle this? Are they bound by this, I should say?
Yes, once it becomes a rule, the respondent's attorney are bound by all of them, including this.
And so is it the understanding of the board that as written is fine because one can assume that the respondent representative is represented, isn't it?
And the party only goes to number 2. of that.
Yes,
Say that again, I'm sorry. It's that.
Party only number 2.
defines party in item number 2. It's the only place the word is
Okay.
written.
Okay.
Item 3. Any additional questions before we move on? Form and content of motion. Any questions, thoughts? Section 4, time for filing. Yes. The motion shall be filed with the ethics office and served on all parties. The motion shall be filed no later than, we're gonna take that out completely, that sentence out. Motion shall be filed with the ethics office and served on all parties, period. That's it.
I think by taking that one out, the next sentence probably needs to be.
Just prior to date set for compliance, whichever one occurs first will go away.
What do you mean?
Because what else, there's not one or the other, it's only prior to. Because it's not saying, we're no longer.
Yeah.
Failure to time it out.
Okay. The rejection is a yes. So are we keeping prior to the date set for compliance? We're taking it out completely?
Yeah, I think that comes out.
That whole sentence is fine.
So we're gonna take it all out.
Sentence.
Okay.
And I think that's.
And then the last sentence, perfect.
But I'm sorry. Let me just look at that one for a second.
Motion.
Well, this is my opinion. I think failure and then take out the timely, failure to file shall constitute a waiver of objections absent of showing of good cause.
If they don't file, there's nothing to waive.
Okay.
So we're keeping timely?
I think the whole sentence.
Yeah, only one, so the only thing that stays is that first sentence, everything else comes out.
Okay.
And then the section name will have to change instead of time of filing.
Yeah, it would
It's
be-
method of filing.
Or do you add it to next week? Section 5, service of motion.
I'm sorry.
Yes.
Especially if we're gonna change section 4 to method of filing. I feel like I thought I saw it somewhere, but maybe I didn't. How are you? By email, in person?
Section 5.
Okay, I was gonna say, I knew I read it. Okay, I'm sorry.
So it sounds like 4 and 5 really need to be combined into one
Yeah.
section and remove section, the service
Yep,
part.
yep. Okay, so moving on to service of motion to quash or modify witness subpoenas shall be made by personal delivery or by electronic mail to the ethics administrator and to the last known email address of record for all parties to the proceeding. Service by electronic mail shall be deemed complete upon transmission. My only question is, are all parties receiving emails? Because how can be confirmed that it's sent via email? Are we sharing emails? All the witness emails with each party.
So typically when they file an answer, they file with their contact information. If they don't give us their email, then the only thing we have is an address or they have to have their email address because they have to email you the answer. So we would have record of their email address. That's the only way that they can file a responsive pleading is by email.
And realistically, especially if we're looking at it, this is the motion to quash, they're gonna be the one. So
That's
that's how they're sending it to us.
That's my point. So if they're sending, if the responsibility is for them to send for all parties to the proceeding, that mean if I'm a witness, I have to send it to the complainant, to the respondent, and to the ethics office. How would I have, who's giving me all those email addresses?
I agree. That needs to come out because if, once they serve the ethics administrator, it's
She
the
should
ethics
share it
administrator.
with everyone else. There we go, because they don't have, how can you
Uh-huh.
confirm that they have the right email addresses to serve?
Okay, so let's make that change before I say what I'm gonna say. So what we're doing, we're removing the service motion.
We're moving into the last known address of record for all parties of the proceeding.
Let me make sure we're,
Yes, sir.
okay. All right, then, like,
Putting that responsibility onto the ethics administrator.
it changed what I was gonna say. That's why I wanted to clarify that first. Okay, so basically, we're consolidating 4 and 5, correct?
Yes.
Okay, so we're changing, making a major change, because we're making major changes on both of them.
Sorry?
Yes,
Yeah.
but remember, this is not a part of the policies and procedures yet. This is all, we're doing this now. And then we're gonna come back in our next meeting and vote for the amendment for this to be added.
Okay,
But we're just correcting language.
all right. So what's left in 5?
What's left is
The parts of 4 that we're keeping, it's gonna combine with 5, and 5 will be and it's gonna be reworded a bit. Service of, I see you, Ms. Willingham, 1 second. Service of motion to quash or modify a witness subpoena shall be made by personal delivery or by electronic mail to the ethics administrator. So in other words, that's it. It stops there. We're not putting that responsibility on the respondent or witness or complainant to send it to all parties. We're gonna keep that responsibility in-house. And then we'll keep service by electronic mail shall be deemed complete upon transmission. Ms. Willingham, you have a question?
I do think you need to add something acknowledging that the ethics administrator will distribute
Okay.
to all parties.
Add language. Dr. Valme, you had a question?
And what's the consolidated title? What would the consolidated title be?
Method of filing.
Is it method of filing? Because we took away the service, no, we still have service of motion.
No, that's going away. So both those titles of section 4 and section 5 will be combined into the method of filing.
Okay, so we took away the service. No, read that, but you kept, because you said service of motion. You removed the title, but you still use service of motion. Method of filing.
The way it will be
I see what you're saying. We're gonna
Yes.
do both. So it's gonna be a combination of information. So just like section 3 says form and content of motion, it's gonna say time for filing and service of motion.
we took the time for filing out. So the way.
No, it's
Filing and
It's
service.
method of-
How about we just say filing and service? Okay.
method
Filing
and,
slash search.
Yes, it's gonna say filing and actually.
I'm sorry, no, say it again.
It's gonna be,
One is filing and the other one is service of motion.
yes. So filing and service of motion.
Okay.
It's 1 and 2.
And then add language that says the ethics administrator shall serve all parties of record.
Are there any additional questions before we move on to item 6?
Section change.
Sir.
Yeah, remember, we gotta invert to sections that change.
Oh, yeah, so now we're
Change.
at section
Six.
5.
We're at section 5 of
No, no,
the.
no, 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 no. So let me clarify, because I don't want to be confused all the way through with misnumbering. We're gonna call them what they are today, but what they will become, yes, every number will change, except starting with 4. They're gonna be a different number, but right now, it's 6. And I do see. So effective filing. The timely filing of a motion to quash or modify shall automatically stay the obligation to comply with the subpoena pending a ruling by the Board of Hearing or hearing officer unless otherwise ordered. Ordered to do what? Well,
I think you gotta go back to timely again too.
That's what I was about to say.
I was gonna say, I don't like this whole section.
I was concerned. You see, I already,
And I didn't like it even before
Yeah.
we talked about the time, so, just so you know.
Wait, which one is it?
The, effective filing, section 6.
so are we taking this out completely?
I have a concern about the automatically stay the obligation.
That's why I don't like it.
That's why I don't like it.
That's what I have underlined automatically.
I mean, at the liberty of board, something like that,
Yeah,
I would carry that. Yeah, the board discretion
Yeah.
to stay, but even if you just take automatically out.
but
But
still.
so
it
here's my
says
question about that. So when you
constitute
file the motion, what happens? You just move forward with the hearing?
You have to-
Goes to the hearing officer, and then the hearing officer will make the determination of how to move on. That's what we did with the last.
Right, but isn't that what this says?
Yeah.
That means I don't have to comply with it until the hearing officer says whatever their ruling is.
I think my concern with that though is if we don't have a time limit and they want to file that motion to quash that morning and they don't show up because they filed a motion to quash, their argument is it stays.
Oh, I see what you're saying.
Exactly, and I'll definitely remove shall.
So so with that, I guess if you want to see it from that perspective, then I guess we can leave stay. I don't know that it's necessary, but in the event somebody filed it, I guess, days beforehand. But maybe just the ethics hearing officer shall make a ruling on the motion. But I don't know if it's needed. It's kind of.
Still get into that one.
Yeah, maybe you
Yeah,
don't, maybe
that's
you
what
don't need it. If
yeah,
they file it that
that's-
morning, you can't move forward until they make a
Right.
determination on it anyway. So yeah, you could
Just
probably take
And
it.
I'm pretty sure, whoever filed it is going to argue that it's not gonna be able to move forward, or it's a party, whoever wanted that person there is gonna argue.
Well,
Yeah.
if it's stipulated in a document, then they have a point.
Get rid of the whole section.
Yeah, right,
Yeah, you can take it. I think you can take it out.
So 6 goes away. See, now 6, there we go.
That's saving paper.
6 is gone.
Next one.
So the
I'm-
effective filing, we have to, so, I'm sorry.
Going back to the question in regards to what happens to the motion, is it clarified?
What happens to the motion?
I'm sorry,
Get down to
Yeah.
9.
section 9?
I think it's kind
Okay, I just want to make sure.
Now we get into numbers again. Because when you get into the authority of the hearing officer, we'll talk about that.
Okay, I see it.
Yeah. 7, we're moving on to 7. Still says 7, responses. Any party may file a written response to the motion for the board or hearing officer's consideration.
I think that's where it should stop.
The response must be filed, yeah, it has to, because we're getting rid of days. Yeah. All right. Section 8, grounds for relief. Board of hearing officer may quash or modify witness subpoena upon a finding that the subpoena is is unreasonable, oppressive, or unduly burdensome. 2, seeks testimony not relevant to the subject matter of the investigation or proceeding. 3, seeks information protected by privilege or other legal protection. 4, exceeds the board's statutory or jurisdictional authority. Or 5, was issued in violation of applicable procedural requirements. The burden of establishing grounds for relief shall rest with the movement. Move it. Is that pronounced? Move it. Yes, sir. Mr. Dr. Bowman.
Got one question for 7, because we just moved on to 8. I got one question. I know, I'm sorry.
That's fine.
You said any party. In the definition and standing, it says persons, any party, any persons. So are we good with that point, talking about parties, not mentioning person?
Yes.
Because a regular person wouldn't have standing to actually respond to the motion.
Those are the affected parties, the respondent, the complainant, and then the board itself, we're all party to.
A party, a
So,
person.
in other words, if a party says, okay, if this witness says, hey, I want to quash the subpoena. This now, as a party to this proceeding, I get to say why I don't think this witness should be able to quash. And then the board and the hearing officer takes the motion to quash in addition to the party's response and decides whether or not to move forward or adjust or amend.
But if a person receives a subpoena and wants to squash the subpoena, not a party, it's a person. It's not mentioned, unless the one trying to say.
That doesn't have the right to say that the subpoena shouldn't be, like, we can respond, the party, the ethics officer, the respondent, they can respond and say why they think that person asking should still have to testify. That person doesn't really have much to say about why they don't think, they've already said it in their motion. That's their response, it's their motion.
Yeah, so in other words, if I'm the witness and I don't want to appear and I quash and so on and so forth, they need to respond. If there are other witnesses that says, hey, I want an opinion in this matter, they don't get one. They're not a party to the case. So we're good with, what about section 8? Do you have any 8?
No,
Authority of the hearing officer, section 9. All motions filed under this rule shall be decided in the first instance by a hearing officer delegated authority in writing by the board. So my question for this is, written permission has to be given every single time the hearing officer makes that determination? Like, we have to give him written? Or can we just give permit, like, by basically making him the hearing officer, in effect, making him the deciding party? Do we need to write that every single time?
Needs to read in first instance by the board or a hearing officer delegated in writing by the board. Because the way it reads to me now, it automatically assumes a hearing officer will always hear it. But what if a hearing officer is not required for the code? That's something this board implemented in order to help facilitate the hearings. So ultimately, if we don't have a hearing officer, the board still has to decide that motion to quash.
Yeah, and I agree with that, because especially realistically, if we end up getting a motion to, most motions to quash are probably gonna come at the 9th hour, but if we get one super early, we have to send it to a hearing officer when we can just decide on it ourselves. So
I'll propose that it says all motions filed under this rule shall be decided in the first instance by the board or a hearing officer delegated by the board.
Shall be decided in the first instance by a hearing officer, or what? I'm sorry.
First instance by the board or a hearing officer delegated by the board.
Then get rid of in writing.
Yes.
What is first instance defined as?
First opportunity. If that can come out too, yes. It can just say shall be decided by the board or a hearing officer delegated by the board.
so are we removing the hearing officer may enter, or are we gonna clarify that as well?
I think it should be removed completely because section, y'all have the original numbers. Mines have changed. Grounds for relief says what the finding is based on. I don't think there needs to be laid out what happened. That's just my opinion. You can only do so much with a motion anyways. You can only deny or grant it. And if you grant it, then you're granting it in whole or with stipulation.
So when I read that, I looked at modifying the subpoena.
Yeah, I thought there
I thought
was,
that was-
like,
yeah.
the reason I put that in there is because I thought there was some language about modifying. I thought this was also spoke to modifying the subpoena because wasn't there a situation where he
In the last
actually
hearing, he
limited
did
the
modify, he
testimony?
did.
So you kind of want to allow,
Granted it,
But
but
it was
he,
modified.
he
yeah,
modified.
so he granted it with stipulations, basically.
Yeah.
So I'm granting your motion to quash in part, and in order for you to be in compliant, you still have to come during these timeframes. So I guess that is a modification part, huh?
Yeah, so I just wanted to kind of lay it out in
Mhm.
case, what if it's not the hearing officer, it's just the board, that we want to know what can we actually do here?
That makes sense.
So, but I think it does have to change from the hearing
Hearing
officer.
officer, yeah, it would have to change.
Hearing officer and or board.
The board right here, officer.
Any order modifying or limiting a subpoena shall be merely tailored.
Sorry.
We're in the same section still.
Okay, just to make sure we're keeping the same sequence here because you had the board first in front of the hearing officer.
Same thing.
Okay, cool.
On my side, it says the board or hearing officer, and above it says by the board or hearing officer.
Okay.
Any order modifying or limiting a subpoena shall be narrowly tailored to balance the board's authority with the legal and procedural rights of the witness. Language stays as is.
That's just a fact that's stated.
Yeah. Section 10, hearing and ruling. The hearing officer may rule on the motion without, of course, we're gonna say the board or hearing officer may rule on a motion without oral arguments unless a hearing is requested in writing and or good cause is shown, or no, and good cause is shown. Any ruling shall state the basis for the decision.
Outside of the adding of the board, I think that.
I think so too. You need to weasel yourself out of that.
It still says 11, but it could be 9. We're going to review a hearing decision. A party agreed, yes, invite officer. A party agreed by the hearing officer's ruling may request review by the full board within 7 business calendar days. We'll have time for that.
I think we should take the time limit out, but I like the.
Okay.
I think, I don't know if this is my train of thought, but I like the fact that it shows the hearing officer is not the ultimate decision maker of this board.
That is what I was, because initially I was thinking the hearing officer would hear it. I wasn't even thinking about there not being one, but that does make sense. And then if the person feels unsatisfied, they could say, I want the whole board to hear it, and they make the final call.
What's the difference between what this language here and an appeal?
It may not be different because ultimately you're asking someone else who has decision-making authority to review it to make sure that the person made the right decision. But this wouldn't be considered an appeal because it's not the hearing officer is only delegated decision-making authority by the board. If a party feels as if that hearing officer misused that decision-making authority, they can then seek the board to review what the hearing officer did.
And if my question now is, would it not be beneficial to them to appeal rather than go this route?
They couldn't appeal. So the code only gives them the right to appeal a final decision of this board. And the decision is from the complaint itself, not from a procedural motion.
This is just a decision for the motion to quash,
not for the decision.
Yeah, that's where I was confused.
Got confused
I
about.
was confused about that.
Because I was like, what if somebody comes back from 2022 and it's like, hey, you know, put a time on it.
Sorry.
Okay. Yeah. I was reading that.
Yeah.
So,
Talking about the peanut. Thank you for that.
Well,
does that matter?
No, because,
no, I mean, I don't care.
because we took all the other days out.
And then we're taking like number of days out.
Yeah, we took all the other days out. This is just for the peanut. I was confused. Like, wow. Different.
So, I want to make a
Wait,
motion.
so what did you guys just decide with section 11? But it did make.
Take out within 7 calendar days of issue.
Keep everything else.
I just, yeah, I need one there. Is it not part of procedure?
Wait, I'm sorry.
The time limit doesn't make sense, all right? The time limit.
Right, the time limit doesn't make sense, but another thing that I think might be an issue is full board.
That's
By the review by the full board.
Yeah.
Because if they, in the instance where the motion to quash comes up the day of the hearing, we may have a quorum, but we may not have.
Motion to decide.
Actually put, I think,
Yeah.
about the board.
Mhm.
Make sure to take that full out.
In my head.
Yeah.
Okay, the only thing I do have the question about, and maybe this is just to talk through it. Okay, so if the hearing officer. If the motion can be heard by the, and move on by the hearing officer or the board, the hearing officer says is denied. And now the hearing is gonna go forward today, right? So what? How would the person, I mean, why would, in what case would this person then later come back and be like, oh, I want to?
We'd be there.
Yeah.
If it's a if it's at a hearing, and the
Right.
hearing officer denies it, we're there. So we could, I think you could procedurally take that up before, if they say, well, I want the board to review. Now, what I think is gonna happen in those instances is they're always gonna say,
Yes, I just,
yep, I want the board.
I think
to
so
review."
too.
But I mean, I think in that instance, we're there.
And at that
And you
point,
can either agree, I guess, with
Yeah.
the hearing officer's ruling or not, right?
Mhm.
Okay.
and at that point, the way I foresee it happening, if it was to happen, is the board would have heard the argument.
Right.
Because we're already there as the hearing officer. So it's not going to delay further. At that point, the board just deliberate and either grant it or deny it based on how the board feels at that time.
Continuity, just the second sentence, add the board instead of board.
Last item, meeting space was part of. It's just, procedure policies of maintaining, or being in compliance for the Open Meeting Act. We are going to look into, moving our monthly meeting to a larger space so that we can accommodate the public. And then we will more than likely also open the floor up and give the public an opportunity to ask questions prior to or after. Make statements rather than ask questions, make statements prior to or after the ending of our meeting. And we're gonna look into streamlining our hearing process so that we're having our hearings and our meetings on the same day. So that's for continued discussion. So looking, for your emails about us trying to figure out where we can move this meeting, how we can take equipment that we already own because we don't have the budget to purchase any equipment. Our last hearing went over poorly. No one could hear, could barely see, and we got a lot of complaints about the audio on that particular one. So we're gonna see if we can rectify some of those issues and move to a larger space for the public. Are there any questions? Okay. And with that, would someone like to make a motion to adjourn?
Make a motion to adjourn.
Second.
All in favor? And done.
Bad.
Bad. See that?